Hi, my name is Matt Merowitz, managing attorney for the Merowitz Law Firm, and today I'm going to talk about the stages of a criminal misdemeanor case in Arizona. So, first of all, a criminal misdemeanor case can get filed one of two ways. Either the officer can file the charges, or it can be filed by what's called a long form complaint. Now, the first method, where the officer files the charges, this is in the form of what's called an Arizona traffic ticketing complaint. And this is what sometimes you might hear what people call a citation. This is where the officer writes down on your ticket the charge or charges, hands you the citation, and normally on the top it will say Arizona traffic ticketing complaint, and that is the document that ultimately gets filed in court. Normally, it will also include a summons to appear. You'll have to sign for your court date, and it'll tell you when you need to appear in court to address the charges. And then the second way is the long form complaint. That's where not the officer, but instead the prosecutor is the attorney for the state is the one who files the charges. So normally that occurs when the prosecutor reviews, for example, the police report, and then decides to charge you. And then they'll file the complaint in court. Now, the first court date, and this is what's listed on the Arizona traffic ticketing complaint, or in the case of a long form complaint, this would be included in the summons. This is your first court date, and this is the arraignment. And if you don't have an attorney, it is extremely important you don't miss this court date, because otherwise, when criminal misdemeanors are involved, a warrant will be issued for your arrest because it is a criminal case. So it's extremely important that you don't miss this date. And the purpose of this date is, first, it's your first court date, as I had mentioned, but it's for the judge to advise you of the charge or charges that you might be facing. Additionally, the judge is going to tell you about the range of possible penalties for each charge if you were to be found guilty. And that's also where the judge is going to determine whether you're pleading guilty or not guilty. Now, if you do find yourself facing a criminal misdemeanor, while I can represent someone typically at later stages in a criminal proceeding, it's ideal to hear about this immediately. And if I'm contacted before the arraignment, a lot of times I can accomplish the purposes of the arraignment without my client ever needing to be in court, at least in a misdemeanor case, because I will file a not guilty plea on my client's behalf. And for many courts, my client won't need to actually attend if I'm hired in advance. Now, when a not guilty plea is entered at the arraignment, the next court date is typically going to be some form of a pretrial conference. A lot of courts may call it something different than a pretrial conference. Sometimes you may hear status conference or pretrial disposition conference, but it's all some form of pretrial conference. And in rare circumstances, if you plead not guilty at the arraignment, the judge will set it directly to trial, but that's extremely rare. And on my cases, I will request a pretrial conference because there's some very important objectives that can be accomplished through the setting of a pretrial conference. So a pretrial conference is a meeting between the prosecutor and the defense attorney, if represented. If a defendant is not represented by an attorney, a lot of times the pretrial conference will just be the prosecutor and the defendant. This is normally the deadline for the prosecutor to provide the initial discovery. So the initial discovery, a lot of times this is the police report, and it may include some other pieces. And then this is also to pretrial conference to help determine the status of a case and the status of evidence. You can have multiple pretrial conferences. So a lot of times the case won't resolve at the first pretrial conference. So it may be continued, and there may be a second and sometimes even a third pretrial conference. On cases that I'm involved in, a lot of times I don't get everything that I need to properly handle a case at the first pretrial conference. And when I represent a client, I don't leave any stone unturned. So the police report, which is typically given to me at or before the pretrial conference, I'm not normally dissatisfied with that. I will request everything that is relevant to my client's case. So I'm going to get the body camera, the surveillance if it exists. And a lot of times that won't be made available at the first pretrial conference. So for that reason, there may be multiple pretrial conferences so that I can get all relevant discovery on a case. And then finally, if the case is going to resolve through a plea, a lot of times this will be done at one of the pretrial conferences. Now, if a defendant is maintaining their plea of not guilty, then the next step after pretrial conferences is trial. So trial is where a judge or a jury decides whether a defendant is guilty or not guilty of the charges. And I put judge or jury because in misdemeanor cases, a trial can be either through a judge or a jury. So a lot of people think of on TV, oh, it's always going to be a jury of your peers that's going to be deciding a case. But in misdemeanor cases, a lot of misdemeanors are actually not jury triable, meaning the judge may decide whether you're guilty or not guilty. A trial is where the evidence is presented, basically, through a trial, the judge or the jury is going to listen to all the evidence, and then at the end of the trial, a judge, or in the case of jury-eligible misdemeanors, the jury will decide whether you're guilty or not guilty of each of the charges alleged. And sometimes you may have kind of a hybrid. You may have multiple charges, and some of them may be jury triable, and some may not be jury triable. And in cases like that, the trial will still be held to a jury, but at the end, the jury is going to decide whether you're guilty or not guilty of jury triable eligible charges, and then the judge will decide the remaining charges. And if you are found guilty of any of the charges, then there will be a court date called sentencing. And in misdemeanor cases, a lot of times this will happen the same day, but sometimes, in the same day of trial that is, but sometimes sentencing may be pushed out to a later date, particularly when there may be some outstanding issues, such as if there is a victim that is possibly requesting restitution. That may involve certain documentation that may not be available at the time that a judge or a jury finds the defendant guilty of charges. Now, of course, if you're found not guilty of charges, then that's the end of that. So you should get paperwork saying that you are not guilty, and then you're done. So those are the basic stages of a criminal misdemeanor case in Arizona. Every case is a little bit different, which is why it's extremely important to contact an experienced criminal defense attorney like myself if you find yourself facing any charges whatsoever. And while, as I mentioned, I can ordinarily still represent someone later in the process, the sooner the better. So don't delay. You have nothing to lose from a phone call to me. My phone number is 480-927-3700, and the consultation is always free. I look forward to hearing from you.